Okay, picture this. It's 1982. We're in a newspaper office in Edmonton, Canada. And, a simple knock at the door is about to kick off this massive legal firestorm, one that, believe it or not, ends up defining one of your most important rights today, your right to privacy from the government.
I mean, think about it. When can the government actually search your property? When can they just walk into your home, your office, or start digging through your data? It's a huge question, right? It goes right to the heart of what it means to be free. And in Canada, the answer we have today was basically forged in this wild, high-stakes legal drama with just unbelievable timing.
Seriously, you can't make this stuff up. It's a total collision course. So you've got this really powerful search authorized under an old kind of vague law. Then, just 3 days, literally 3 days before the investigators are supposed to show up, Canada brings in a brand new constitution with a shiny new Charter of Rights and Freedoms. Yeah, a showdown was pretty much guaranteed.
All right, let's get into it. So that knock at the door comes on April 20th. It's investigators from something called the Combined Investigation Branch, and they show up at the Edmonton Journal. They've got their authorization, and they are ready to search everything. We're not talking about one specific filing cabinet here. We're talking about maybe every single file in the whole building.
And this warrant? Wow. The Supreme Court of Canada later said it had a breathtaking sweep. It wasn't looking for a specific piece of evidence. It let investigators go into the newspaper's offices, not just in Edmonton, but elsewhere in Canada. Just anywhere. The court basically called it a fishing license. And that's when the newspaper said, no way, and decided to fight back.
So this was way more than just a typical legal challenge. It was really a showdown between two totally different eras. In one corner, you've got the old way of doing things, where the government had this huge amount of power. And in the other corner, a brand new constitutional right designed to protect you, the individual. The stage was set for an absolute classic.
Okay, so here's the conflict in a nutshell. You've got the old law, the Combined Investigation Act. It basically said the director could go in if he believed there might be evidence. That's it, just a belief. Talk about a low bar. And then you have the new law, Section 8 of the Charter, which promises everyone security from unreasonable search. So, which one is it going to be?
Well, that question ended up at the Supreme Court in a case called Hunter v. Southam, and they had this massive job ahead of them to figure out what that word unreasonable actually means. And this was the first time they'd ever have to define it under the new Constitution.
So where do you even start? Well, the court started with this really powerful idea. They said, look, this right to be secure, it's not just about getting some money back after the police have already tossed your place. What good is that? No, its real purpose is to be a shield, to stop the government from making an unjustified search before it even starts.
Okay, so with that goal in mind, that Section 8 is a shield, the judges looked at the old law, and they pretty quickly realized it was full of holes. It couldn't provide that protection. In fact, they found two huge, fatal flaws that made the whole thing unconstitutional.
First up, and this is a big one, the person who actually signed off on the search, they weren't neutral. They weren't a judge. They were part of the same team that was doing the investigating.
Right, and that flies in the face of a legal principle that's been around for centuries. Nemo judex in sua causa. It just means no one is a judge in their own cause. It's like having the referee also be the coach for one of the teams. It just doesn't work. The court made it crystal clear. The person who approves the search has to be impartial.
And in this case, the group that okayed the search, the Restrictive Trade Practices Commission, was anything but neutral. Look at what they could do. Start inquiries, collect evidence, tell people to investigate more. They were basically part of the prosecution. There was no way they could be an impartial check on government power.
Okay, so that was flaw number one. The second fatal flaw was the standard you had to meet to even get a warrant. Under that old act, the bar was frankly on the floor. The investigator just had to believe there might be evidence. That's it.
The court had a great term for this. They called it a license for fishing expeditions. And that's exactly what it was. It meant the government could go rummaging through your stuff based on nothing more than a hunch, a suspicion, not on actual credible evidence. And that, the court said, tipped the balance of power way too far towards the state.
But here's where things get really interesting. The Supreme Court didn't just tear down the old law and walk away. They did something much bigger. They actually built the new standard. They forged that shield that Section 8 was always supposed to be.
So what does that shield look like? Well, the court laid out 3 basic rules for any search to be reasonable. 1, you need prior authorization, basically a warrant.
2, that warrant has to come from someone neutral, like a judge. And 3, this is the big one, to get that warrant, the state has to swear under oath that there are reasonable and probable grounds to believe a crime was committed and that they'll find evidence there.
The court had this amazing line to sum it all up. They said the crucial point is where credibly based probability replaces suspicion. And boom, that's the game changer. The government can't just come knocking because of a hunch anymore. They need probable cause. Your privacy is now officially protected from those fishing expeditions.
So a case from 1984. Why does it matter so much to us today? Well, because its legacy pretty much defines the line between your privacy and the government's power, every single day.
I mean, the impact was huge. That 3-part test, get a warrant from a judge based on probable grounds, that became the absolute minimum constitutional standard. It's the baseline. Any law in Canada that allows for a search has to meet that standard. If it doesn't, it's toast.
You know, you hear that phrase all the time, a reasonable expectation of privacy. Well, this is where it really gets its teeth. This is the case that says your right to be left alone is the default. It's the starting point. And any government intrusion has to be justified with solid evidence before it even happens. And that kind of brings us to the big question for right now, doesn't it? These rules were made for a world of filing cabinets and paper. So how do we make that same shield, a warrant from a judge based on probable cause, how do we make that work to protect our digital lives? You know, our phones, our DMs, all our data in the cloud. That's the challenge that this nearly 40-year-old case leaves for all of us today.